Mr. Kaucha,
May please you
may just as a prelude say that we are going to hear your arguments, and we want to hear everybody on this application, on your client's application, and we make a determination later on. So we're not going to give a ruling now, but we are not going to preclude anybody from making submissions before us.
Yes, please.
Yes, please.
Yes, Chief Justice, but our main argument will be led by Advocate Premit for an hour. I will do the reply. Yes, please.
Very well. Okay. Mr. Premit.
Thank you, Chief Justice. Chief Justice, members of the court, I had prepared to address a couple of points in front of the court, which I'll be willing to do so at a later time, because there are really two critical issues this court has to deal with. The first critical issue is if the so-called extension of the election is unlawful, can it survive? That's the lawfulness point. And the second question related to that is if we come home on unlawfulness, and when I say we, I mean the LPM and the IPC, because you know there's a parallel synergy between our two applications, do we even have to engage the materiality debate? And let me highlight what my answer is going to be on materiality. The first point under materiality is that it doesn't matter, because when you're in a V-Raise challenge, you're asking an anterior question: do you have the power to do the thing that has to amount to a material irregularity? If you don't have the power, ipso facto, it's a material error. But secondly, to the extent that materiality is at play in this matter, we submit we meet the threshold of materiality. So let me start with lawfulness, if I may. There's a judgment from this court in the matter of Swart versus Brunt, 2003, Namibia Supreme Court 16, delivered on the 28th of October 2003. And what this court does in that matter is it endorsed the following statement by Lord Denning, which is this: if an act is void, then it is in law a nullity. It is not only bad, but it is incurably bad. So let's just stop there. Simply put, absent V-Raise, it's a legal nullity, and it's incurably bad because you can never apply a materiality threshold to something you never had the power to do in the first place. And the court went on there. The court went on to say, and let's just, with all due respect, Chief Justice, listen to how much more robust this court was in 2003, because it endorsed this additional principle. It said, there is no need for an order of court to set it aside. It is automatically null and void without ado. And then the court went on to say, though it is sometimes convenient to have the court declare it to be so, and every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Now that proposition, Chief Justice, members of the court, is not controversial, because the members of this court have applied it in numerous instances. Just 2 years ago, in the matter of Newpoint Electronic Solutions Pty Limited versus, I think it's Principal's Permanent Secretary, Office of the Prime Minister, 2022 Namibian Supreme Court 31, 3 October 2022. This is what the court says at paragraphs 42, 43, and 44. I'll read. It is axiomatic that the Republic of Namibia is a constitutional state, and in a constitutional state, the principle of legality reigns supreme. What this means is that all state institutions and public officials may only act in accordance with powers conferred on them by law. Now, I know the respondent's argument against me is they do have that power, and I'll come there in a minute, and I'll show you they don't have that power. But what I'm focusing on for the time being is a first principle question. If a public official acts outside their powers given to them by an enabling instrument, ipso facto that conduct is unlawful. That's why the court went on to say at paragraph 43, This court has, on numerous occasions, stressed that the principle of legality demands that the exercise of any public power must be authorized by law, either by the Constitution itself or by any other law recognized by or made under the Constitution. The court furthermore made it clear that the exercise of public power is only legitimate where lawful. So all we are asking this court to do in the LPM application, at least, is look at the statute. If the statute doesn't enable the extension, it's unlawful. We're asking the court to apply its own authority from SWAT and now in New Point, which is White Paris 42 and 43. The court has already said this. But listen to what the court says in paragraph 44. If public functionaries purport to exercise power or perform functions outside the parameters of their legal authority, they, in effect, usurp powers of the state constitutionally entrusted to legislative authorities and other public functionaries. It is against that background that it seems relevant to first set out the statutory framework, and then the judgment goes on. And this court, with all due respect, has applied that principle from SWAT in 2003, New Point in 2022, in other matters as well. In the matter of Kowojo versus Minister of Mines and Energy, Volume 2, 2020, NASC 21, Deputy Chief Justice Damasev and Justice Smuts, at paragraph 53 of their judgment, were at pains to emphasize that the statute, where it prescribes conduct by a public official, has to be complied with. That's also why, for example, this court in Anhui, and I apologize if my pronunciation is incorrect, but in Anhui, Chief Justice Shivute, Justice Mainga, and Justice Smuts, at paragraph 69 of that judgment, also went along to say, and you'll remember the facts of that case was an unlawful procurement issue, and the question was whether or not the court invalidates the unlawful procurement in order to institute the correct lawful position in law. Listen to what the court says with all due respect. There is also compelling public interest in vindicating the Constitution and the rule of law by setting aside invalid administrative action. No coherent reasons, and with all due respect to our learned friends for the respondents, we say they're in this territory, no coherent reasons. No coherent reasons have been advanced for the amelioration of the rule of law. On the contrary, considerations of factual certainty also impel the setting aside of the directive in that case. Until the directive is set aside, the NAC is obliged under Section 9.2 to adhere to it. Nor was it explained how severance could conceivably be applied, nor was it stated where parts of the directive should be severed, and so on. So the point is that in Anhui, is that this court does exactly what the LPM is asking the court to do here. Look at the statute, and if the statute doesn't create the power, anything done purportedly in pursuance to the unlawful misconstrual of that power is ipso facto unlawful. Because let's remember two things about the Electoral Act. And I'm not going to repeat what my learned friend Mr. Katz has said this morning. But there are two simple points about the Electoral Act. Even if we assume in favor of the respondents that they can change the electoral timetable, they can extend the election, they can do whatever they want to do, that is time-bound in terms of the statute. It has to happen before polling opens. And what do we know on the facts here? It's worse for the respondents. Why is that? Because the 27th, which was the only election day, comes and goes, and then some very high-minded individuals, no doubt represented by counsel and duly advised, talk among themselves and say, hey, we've got a crisis. How do we solve the crisis? I know, let's extend the election. And when did they extend the election? They extended a whole day after the polling period comes and goes. So even if our learned friends in theory could advance on behalf of their clients, that their clients have this power somewhere to extend the election timetable, They had to do it before the polling period commenced. And on the common cause facts, they did it afterwards. With all due respect to our learned friends, game over. Because having regard to what this court said in Swat, what this court said in Anhui, what this court said in the other judgments that I've mentioned, the point is simple. Statutory non-compliance of that kind is unlawful, finish and clout, if I may say that. That's the first point, emanating from the facts of this case. What's the second uncontestable fact emanating from this case? Is that the President, duly advised, exercises the power he says that he has. But what does he do, and how does he justify those powers? The first thing which is obvious, and Mr. Katz spoke about this in the morning, is that the Electoral Act doesn't give the President the power to extend. Under the appropriate circumstances, it's either the presiding officers, which you will know, the presiding officers have a power to extend voting for anyone who is in the line when the voting cutoff period happens. The President is not a presiding officer. So assuming there was this power of extension, he can't rely on that. That's the first point. The second point, which Mr. Katz addressed in the morning, I'm not going to develop much further, is that it's the ECN as the relevant statutory authority, not the President. But let's look at then the two other arguments, because remember, I'm still addressing lawfulness. And remember, Chief Justice, members of the court, if my learned friends can't get over the lawfulness threshold, then everything they say in opposition to this matter falls down in the construction of the case, having regard to what this court has said on lawfulness challenges. So let's look at the two other things they look at. The first thing they look at is Article 32(1) of the Namibian Constitution. I have a copy here in front of me. I don't know. Well, it's a bit presumptuous for me to ask if the court has a copy. The court probably knows it better than I do. But if we look... beg your pardon, my lord?
It's Constitution Day.
Yes, exactly. Let's just look at Article 32(1). Because what Article 32(1) says, in relevant part, is that the President as head of state shall do all of these things. He shall uphold the law, protect and defend the Constitution as necessary, perform his functions with dignity, perform his leadership, all acts necessary, expedient, reasonable, incidental, all of those things. So far, it seems to be in favor of what my learned friends contend. But here's the kicker. In line 4 of that clause, after the comma, it says, subject to the overriding terms of this Constitution and the laws of Namibia. And then it goes on to say, which he or she is constitutionally obliged to protect and administer. So let's just stop there. Our learned friends argue the President has this ability to do these ancillary things. And I know they make quite a bit about ancillary powers under the Ambambungane case, which I'll talk about just now because that doesn't help them. But be that as it may, let's assume that they're correct. What the very clause in the Constitution that they rely on tells you is that it is subject to the law and the Constitution itself. So you can't look at the Electoral Act and say, okay, there's a gap here in the Electoral Act. It's creating a situation which the law doesn't seem to cater to. And then, using Article 32, invent for yourself the power to address the gap. Because, as I read out at the beginning, that is taking the ancillary power into the territory of lawmaking power. And what this court will remember from Swat Boy, the Swat Boy appeal judgment, which some members of the court, I think, wrote in, Justice Smuts, if I'm not mistaken, might have written the judgment, is that in Swat Boy, you'll remember that the Speaker contended that the rules were insufficient and that the rules did not cater for factual scenario that the Speaker confronted, and so the Speaker relied on a generic power to cater for unforeseen circumstances to push for the suspension of Mr. Swat Boy. And what you'll remember is this court overturned that suspension on the basis that you cannot read in these ancillary powers in a way when the rules themselves govern how suspensions are to happen, and secondly, to create for yourself a power that is not actually spoken to in the rules themselves. We say that the SWAT boy logic of this court in setting aside the Speaker's unlawful suspension of the Honourable SWAT boy applies a fortiori here in respect of the President's Article 32(1) submission. So the point is the Constitution doesn't give him the power in the way that the President suggests it does, and secondly, the Act doesn't give him the power in the way he purported to apply it. Let's look at the other last thing, because remember, it's three things our learned friends for the President rely on. It's the Act, which I've dealt with, it's the Constitution, which I've dealt with, and the last one is it's the proclamation regarding the interpretation of laws. And this is from my learned friend Mr. Heathcote's bundle that he handed up this morning, which I'm very indebted to him for doing so, because that makes it convenient to demonstrate how it doesn't help them, is that in Article 9(1), which is the one that they rely on, remember at page 74 of this bundle, it says, when a law confers a power or imposes a duty, then, and here's the important part, because this is the qualifier, unless to the contrary appears, the power may be exercised and the duty shall be performed from time to time as occasion requires. So now the intention in the Act, which is the clear wording of the Act, tells you if there's this power of amendment, it has to happen before polling opens. What do our learned friends do? Our learned friends, well, not our learned friends actually, their client, our learned friend's client, the President, relies on this provision to say, but I can now extend the power. But he ignores, with all due respect, the qualification, because the contrary intention is evident in the statute. And just think about it logically, with all due respect. Imagine this President, this incumbent President of the Republic that Mr. Heathcote acts for, not the incoming President. Imagine this incumbent President was seeking re-election. And during the votes, he decided, you know what, the numbers don't look very good. I'm going to use my power to extend the election, either during the election or after the election. This court would have no difficulty in setting that aside as an abuse of power. The fact that this President is an outgoing President and does that makes the legal breach no different. And relying on this court's own authorities about how lawfulness operates in these circumstances, with all due respect, we say that the attempt to rely on all those provisions I've highlighted to you already doesn't take the matter any further. It's no justification at all in law. Because look at what the court says. This is the High Court in the Namibian Employers Federation. As the function performed becomes invalid. And then you'll see in page 13 of our heads of argument, in that quote, we cross-reference that to the affordable medicines doctrine, which this court our learned friends are in great difficulty, because we know on the facts the President purported to extend the election retroactively and after it had already concluded, which is not empowered to do. And to the extent there's any argument about helping out people stuck in the line, we also know that's of no assistance to the President, because that's something given to the presiding officers, not the President himself. Now, I know there might be a concern by this court about what both the IPC and the LPM are asking for, because in effect we're asking in different ways for the entire election to be set aside and to be rerun. And what we know is our learned friends seem to hedge their bets a little bit. They sort of half contend it's a separation of powers issue, but then don't make the full argument that it's not a separation of powers issue. So let's deal with separation of powers, if I may, Two simple points about separation of powers. First things first, this court's role is to ensure that all decisions made in public law are constitutionally compliant. Not novel, it comes from the judgments that I've just read out earlier. It flows as a matter of course. So when there's any issue about separation of powers, or rather an alleged issue of separation of powers, we know that this court doesn't shirk its responsibility to set aside unlawful decisions, even very important ones and even very significant ones, because that's how constitutional supremacy works. And I think my Lord, the Deputy Chief Justice, Justice Damasev, in a matter called Trustco Insurance, trading as Legal Shield Namibia and another versus Deed Registries, Regulation Board and others, I apologize, it's a very long citation, NASC 10, 15 July 2011, which was also quoted in the other matter from the High Court, Dupree versus Minister of Finance, 2011 NAHC 92. But at para 31 of the Trustco judgment, what does my Lord, the Deputy Chief Justice, say? I beg your pardon, Mr. Heathcote seems to be saying something. I don't know if he wants to interrupt.
I said it wasn't your lordship, it was Justice O'Regan. That's what I remember.
Ah, I see. Well, then my learned juniors are going to get it from me after the hearing. I'm indebted to my learned friend, Mr. Heathcote, for making that correction.
Intellectual property.
Yes, absolutely. But I'm hoping that Justice Damasev won't disagree too much with Justice O'Regan, because what she had to say was not controversial. On the separation of powers aspect, what did she have to say? She said, "It is for judges to decide whether the course of conduct selected by the decision maker is one of the courses of conduct within the range of reasonable courses of conduct available." And reasonable here doesn't mean reasonable plucked out of the ether. It means reasonable as what is permitted in law. And so, again, if there's no lawful entitlement for the president to do as he says, there can't be a separation of powers issue, because all this court is doing is telling an errant public functionary, go back in your place. And this court, the High Court, in a Namibian system founded on constitutional supremacy, does this kind of thing all the time. It's not controversial. Just because this decision might be elevated to being controversial because it has to determine politicians' futures doesn't make it non-justiciable in front of this court, and also doesn't mean that this court can't tell the politicians and the Electoral Commission and everybody, this is how you actually run the election in terms of the statute that you are asked to interpret. So once we have demonstrated to you, with all due respect, that firstly, as a matter of principle, this court sets aside this conduct all the time. Secondly, the authorities relied upon by our learned friends don't actually help them at all. It's not helpful to their case. It's not a source of authority to justify the decision that they've made. And thirdly, there's no separation of powers issue. Then, quite frankly, there's nothing left on the table, because with all due respect, it's unlawful and it must be set aside. So let's go then, if I may, to the second issue, which is, I think, the one that the court was very interested in, and it's the issue of materiality. And if I'm not mistaken, my learned friend, Mr. Katz, was asked a question by Justice Mainga, which was effectively along the, and I apologize to the Justice if I get my understanding of the question incorrect. If I'm incorrect, I know that the Justice will correct me. The question effectively was, if the complaint that you have doesn't affect the results, can it ever be material? That's how I understood the question posed by Justice Mainga. So, can we just take a step back and ask ourselves two questions? The first question is, if you have no power to do the thing that is being complained about, do you have to meet a materiality threshold under Section 115 of the Act? The answer, Justice Mainga, the first part of the answer I'll give, is that you do meet the materiality threshold, because if you don't have the power and you relied on an invented power, for lack of a better phrase, to do something, the consequences of the something that you've done are materially impacted by the error of law that you made. So materiality is different in law to what my Lord, I think, posited to my learned friend as a no difference principle. And I'm going to develop the submission a little bit, but I want to just address Justice Mainga's question up front and give the LPM's position on materiality. The second point is this. The second point is that if I'm not correct about the anterior question problem that the respondents have, and I do have to meet the materiality threshold, then materiality box is also ticked for the reason I've just identified, which is when you rely on an error of law and bearing in mind what the court endorsed in the SWAT matter, it's a nullity. And everything that happens thereafter is materially tainted by the unlawful illegality which scuppers the entire decision. And can I just say this third thing, because I think conceptually it's very important for us to understand what our learned friend's argument is on materiality. Because what our learned friends seem to suggest is that material errors are only ones that affect the result. So in other words, candidate A got 100 votes, candidate B got 99 votes. Or maybe that's not going to help in my mathematical example. Let's give them a bigger margin. Candidate A got 100 votes, and candidate B got 95 votes. And some irregularities were identified such that candidate A received 2 more votes than they should have, and those votes should have gone to candidate B. On the logic of our learned friends, because candidate A goes down to 99 and candidate B goes up to 97, but candidate A wins, then it can never be challenged under the Electoral Act. That's the logic of the argument they make. That's their understanding of materiality, with all due respect. But we will say that that's not correct. And it's not correct for 2 reasons. The first reason is that let's apply it to that logic to the scenario I gave. The conclusion would mean you can do anything unlawful in the Electoral Act. You can change the thresholds, you can do anything you want to do, provided it doesn't change the result. Your unlawfulness must stand, and on our learned friend's interpretation of 115, that unlawfulness must be permitted by the court. That can never be. That can never be for all the reasons, with all due respect, that I've already addressed under question number 1, which is the question of lawfulness.
I'll be very surprised if that's what they say. In fact, this court already said in Idula did 1, but that's not the case.
Exactly.
I doubt if that's what they're saying.
No. But that's the logical endpoint, with all due respect, of how they understand materiality. And the point that we are making is that that can't ever be correct for the reason that has just been identified and for which I'm grateful and associate myself with. But the second reason is this, and it comes from an old judgment. I understand that, like my learned friend for the IPC, the LPM has also delivered 2 bundles of authorities to the court. The page that I want is page 169 of that bundle of authorities. Page 169 of that bundle of authorities. It's the judgment of Hira versus Boyson, which is an old appellate division judgment on materiality. May I just read it out if it's of assistance to the court? Yes. Whilst everyone, I'm getting signs that people are looking and not looking, so I'll just read it out if that's helpful. Page 169 of our authorities bundle. And just listen to what the appellate division says, with all due respect. It says, whether or not an erroneous interpretation of a statutory criterion, such as referred to in the previous paragraph, renders the decision invalid, depends upon its materiality. So in other words, if there's an unlawfulness, and you can draw a golden thread between the unlawfulness as it unfolded and the result of that unlawfulness, that's materiality in law. Not no difference, which the South African court rejected in the all-pay litigation, but materiality. And the court went on there to say this, and just with all due respect, apply what the court is saying to the facts we have here. If, for instance, the facts found by the tribunal are such as to justify its decision even on a correct interpretation of the statutory criteria, then normally there would be no ground for interference. I can't disagree with that. Let's say the president exercised this power of extension before the polling opened and before the polling closed. Then he might be right. The president might be right that he has that power of extension because the facts are there and the statute tells you when the facts apply. But we're not in that territory. So what does the appellate division go on to say? If applying the correct criterion, there are no facts upon which the decision can reasonably be justified. So we say we're in that type of scenario. Because remember, even though they might have identified the power in the act to extend the election, the facts needed to be that you could only exercise that power before polling opened. And on the common cause facts, they exercised that power after polling closed. So on a materiality threshold, we meet the materiality because you see the golden thread. The unlawful result, which is not about does the election result change, the unlawful result is what it is. But it's actionable because of the materiality of the error of law relied upon by the president to get to that end result. And that's what Hira versus Boyson is talking to you about. In this latter type of case, it may be justifiably said that by reason of its error of law, the tribunal asked itself the wrong question or applied the wrong test or based its decision on some matter not prescribed for its decision or failed to apply its mind to the relevant issues. With all due respect, Chief Justice and members of the court, we say all four of those are evident on the facts here. So even though in the construction of the LPM case, I don't need to talk about materiality, the truth of the matter is that we meet the materiality threshold. Because with reference to Hira versus Boyson, we know that that's how an error of law vitiates an outcome, and we're in that territory here. Might I just ask for a moment? I need to consult my team on something. Thank you. Thank you. I appreciate the indulgence. So I was saying that, on the application of 115, even though I say we don't need to tick the box, ultimately we do tick the box. And I've already addressed the point with regard to Hira and Boyson. Can I just point out this? That logic in Hira and Boyson has been applied repeatedly by the South African Supreme Court of Appeal, the Constitutional Court of the Republic of South Africa, and this court might even be familiar with some of those judgments because they get adopted here frequently. The first one is in the African Transformation Movement matter, which was 2022, Volume 4, SA 409 in the Supreme Court of Appeal, and another SCA judgment called Hurt and Carter, square bracket 2021, JOL 50544 in the SCA. And for the benefit of the court and my learned friends, those two judgments which I've just given you can be found on page 19 of our heads of argument, including the particular paragraphs. So, Chief Justice, members of the court, on the two critical issues in this case, we submit our learned friends for the respondents don't have much to argue in reply, in answer when correctly viewed. On the question of lawfulness, you've heard there's no source of authority for them to be able to say that the extension was lawful. And to the extent they have to do some legal gymnastics to get there, because they have to read other acts and other sections and other provisions, that doesn't help them for the reasons I've identified. I've taken you to those provisions, and those provisions show you it doesn't support the conclusion our learned friend suggests it does. And on the issue of materiality, I've demonstrated using the Hira and Boyson line of authority, as well as the ATM matter and the Hurt and Carter matter, that if the unlawfulness is there and it's relied upon for the outcome, that's materiality. And so even under the Section 115 rubric of materiality, we would submit we meet the test. Because how can you ever have an election that is predicated on an unlawful exercise of power to bring that election into existence in the first place? And it would affect the results. Not in the sense that you might have a different winning candidate, but it would discard, for example, thousands of votes that were cast during that relevant period that ought not to have been cast. And that's a further indication of materiality in terms of the unlawfulness that we have here. And so on those two critical issues, my Lord, those are the principal submissions of the LPM. Yes, forgive me.
When did this unlawfulness start?
Which unlawfulness, my Lord?
That's what you have been arguing for the last 45 minutes.
Oh, you mean in terms of the proclamation?
Yes.
Yes, may I?
No, not only the proclamation. You said an unlawful election. I want to know where it started.
Okay. So in the founding affidavit of the LPM, if I may give you the reference, founding affidavit, para 58, page 269, we mention the proclamation from the 26th of September 2024. That's proclamation 28 of 2004, and that sets the election day as the 27th of November. My clients have no difficulty with that. From 7 a.m. in the morning to 9 p.m. at night on the 27th of November. I have no difficulty with that. Then what happens is what we see on the 27th of November at about 3 minutes to 11 p.m. at night. The ECN issues a directive. Doesn't issue a proclamation, it doesn't issue anything of the kind, it issues a directive, and those are to deal with those operational difficulties that the ECN identifies about ballot papers and people stuck in the line and whatever the case might be. And that's at founding affidavit, para 63, page 270. Now what you'll know is my client says that's the first indication of unlawfulness, because when you look at the reasons that were relied upon in the directive, those don't find their way to being expressed in the subsequent proclamation which comes out. And so we say that that disjunct between the first set of reasons and the second set of reasons is where the unlawfulness starts. But then it gets worse than that, with all due respect. Because what you know then, on the 28th of November, is the ECN, pursuant to its resolution, drafted the impugned proclamation. And remember, this is the day after the voting has ended in terms of the original proclamation. So what I'm describing to you now in my client's version is unlawfulness. What we know is that the ECN on the 28th of November drafts the impugned proclamation. That's at founding affidavit, para 70, page 272. It then makes its way to the president. The president signs it on that day. This is para 79, page 275. And the president then extends the election not only for that day, the 28th, but also the 29th and the 30th. And you'll also know from my client, we say the further unlawfulness is that the president only did that in some voting stations, not all. And you know what we say in terms of Article 17 is that an election can't be, a national election can't be run in different parts of the country differently. It is a universal election that must apply to everyone, otherwise that makes a mockery of universal suffrage. And then lastly, if I may, the unlawfulness then compounds on the 28th, 29th, and 30th when voters are allowed to vote. So the unlawfulness starts and ends in a very short window. It's the 27th of November when that first directive comes out, and then as a result of the extension proclamation, if I may call it that, the impugned proclamation, I heard it referred to as earlier, as a result of that, the unlawfulness carries on the 30th, because that's the voting period, and the unlawfulness then persists when those votes are counted. So that's the unlawfulness, with all due respect. I beg your pardon, I'm getting a note passed to me, if I may take an indulgence. Thank you. I'm indebted to my learned leader because he points out something very important. May I ask the court to please go to Mr. Heathcote's bundle handed up during the day, because I again need to draw the court's attention to something contained in there. I'm at page 116. And my Lord Deputy Chief Justice, I'm still answering your question about how the unlawfulness starts and when it extends to. But I want to give a comprehensive answer. I beg your pardon? Anyway, using Mr. Heathcote's bundle, at 116, if we look at paragraph A on page 116, it's about in the last quarter of that page. It says, in explicit terms, by extending the period of the election for the President and members of the National Assembly referred to in proclamation, and then he says, from 2100 on Wednesday, 27 November 2024, until Saturday, 30 November 2024, at 2100, subject to section 93.3 of the Act. Now, there are a couple of things I need to talk about this, because this moves me on to the discussion of remedy. So let me just highlight the LPM position on remedy first, and then I'm going to go back to this proclamation and the Act and discuss it a little bit further. You know that the LPM asks for two alternative remedies. The first one is that if the lawful votes, and now I'm speaking in generalities.
It's a question.
Before you go
Yes,
there,
yes, Justice Mainga.
as I was going through the record,
Yes.
at page 977,
Yes.
your client says, this application aims to uphold the constitutional order, and that is his answering affidavit.
Is it not the replying affidavit, Justice Mainga, 977?
Yeah, replying affidavit, yes,
Yes.
that's right. This application aims to uphold the constitutional order and rule of law rather than to pursue narrow political objectives. And
Yes.
even if it did, that is no answer to
Yes.
unlawfulness.
Yes.
Then on page 980,
Yes.
paragraph 284, he continues to say, this is because the LPM is not running any irregularity challenge. The LPM is challenging the power overreach by the President and the ECN.
Yes.
What ran into my mind is that if this is why the LPM came to court, it's an academic argument. Am I correct?
No, with all due respect, you're mistaken. And the reason you're mistaken is threefold.
Yes.
One, there's the LPM relies on a statutory breach which occurred in real life, which it says it's unlawful.
Yeah.
This court is invited to make a pronouncement on the lawfulness or unlawfulness of that conduct. That's not academic ipso facto. The second point arising out of that is that if this court says it's unlawful and takes the invitation that either the IPC or the LPM invites this court to take, which is to set aside the election, that would not be academic. Because we're asking here for the court to determine...
Set aside the elections, or the way I understand your client's argument, they have no problem with the elections of the 27th, up to 9 o'clock.
Yes. Let me come there on remedy and I'll explain that. But I'm just addressing the question that your Lordship has posed to me.
My problem where materiality comes in,
Yes.
even if your client makes this argument,
Yes.
whether this court says the elections that were held on the 29th and the 30th should be set aside,
Yes.
it makes no difference.
No,
That's where I have a
Yes,
problem.
with all due respect, I've spent a lot of time answering why your Lordship's construction of the no difference principle is fundamentally different to how the courts have interpreted materiality in terms of exercise of public powers. What the courts say is that the no difference principle is not the correct one, because what that would invite is continuing unlawfulness until such time that the result is inverted. And that's why the Deputy Chief Justice said to me when I made this point earlier, but that can't be correct, and that's not the argument that they make. Because if that were the case, as posited in the question asked of me, that would, with all due respect, be an invitation to parties to do whatever it is they could do that's unlawful, provided it falls just short of altering the outcome. That's not, with all due respect, legally defensible. And secondly, that runs contrary to all the public law authorities that tell you what materiality is, and that materiality is not no difference. So with all due respect, Justice Mainga, I think I've addressed your raising 977 and 980 with me in the context of materiality. I appreciate that you might not like the answer, or that my answer may be deficient in answering your question, but I think I've addressed it in the respect of the materiality point. So what I was saying before I addressed that particular question is I was talking about the 93.3 point. So the first one is this, and this is where we are on remedy, and this is also something that Justice Mainga has raised with me, is let's draw a line up until 2100 hours on 27 November 2024. Because that's really where the LPM takes the proverbial line in the sand. What the LPM says to you in terms of its narrow relief is that if there is evidence, which by the way there isn't evidence, so the extent I'm advancing this in front of the court may be self-defeating, but I have to address it anyway because it's on the papers. If there's evidence in front of the court...
Are they saying there's no evidence?
Our clients are saying there's no evidence of what I'm about to address.
From the bar. Because LPM is saying, if you can separate these elections, that's what they are saying.
Yes, that's right.
Yes, but you are saying there is no
No,
evidence. That wouldn't be correct.
No. May I ask the court to please turn to, well, to start at volume, well, I've got it in files. So if we go to page 596, which is where the LPM's founding affidavit starts. Page 645. Paragraph 175, and this is the no evidence point that my Lord Justice Mainga has raised with me. It says, if a fresh election can be avoided by the disaggregation of the good votes appearing from Form 26 dated 27 November 2024, then the fair and equitable relief is to seek to declare the impugned extension and all the votes that flow from that extension as unlawful and invalid. But obviously, absent those Form 26s, which are not in front of the court, that creates a problem for the ECN in particular, because you'll remember the ECN does a mathematical calculation in its affidavit where it addresses the results, but those are not derived from the official results declaration forms, which we have said are necessary to determine the result of the election. So the point here that I was making at the beginning is that to the extent that is theoretically possible, then the court can disaggregate. But if it's not theoretically possible, because there's no evidence, and that's not an issue that...
On that issue of evidence, how does your client deal with paragraph 83 of the ECN's affidavit? And remember, you had in your affidavit challenged the ECN to produce the evidence. Look at...
Give me a second, I'm with you.
Volume 2.
I'm here.
volume 2, page 780.
I'm with you.
Read what they say.
Yep. But that concedes the point.
What do they say?
Which part do you want me to read from, my lord?
I just said paragraph 83.
Must I start at the beginning?
Yes, please.
In addition, comma, no voting took place on 28 November 2024, other than those who voted by virtue of being in line by 2100 on 27 November 2024. Mr. Swart?
How do you deal with that in reply? You are talking about evidence. Their evidence is that no voting took place. And remember, at paragraph 71, page 616, you challenged the ECN to confirm that no voting occurred on the 28th of November. So let's begin to get to the facts of this case.
Yes.
So we're not being too theoretical.
Yes. May I give you
what
the
is said
reference?
there?
I've just read it out. Must I read it again?
Yes, yes. Your reply.
Oh, thank you. 983 at paragraph 309.
Yes.
Ad 82 to 86, which then strikes at 83, which we're discussing about in the answering affidavit. Save for what is stated above, the contents hereof are denied. And remember, what is stated hereof...
That's what you say, you just deny.
No. With all due respect, it's a qualified denial, and it's qualified on the basis that if the ECN's version given under oath, as stated in the answering affidavit, is correct, that no votes occurred on the 28th of November, then as a matter of evidence, what it means is that there's no results on that day, and we can't invent a counterfactual. But it does mean that to the extent that there are votes on the 29th...
Mr. Premier, whose version do we accept? They say there was no voting.
Yeah, and I'm not disagreeing with that. I'm explaining what the consequences of such a statement is if you accept their version with all due respect.
Yes.
May I continue?
Yes, please.
The point then is, my lord, if I can start here. Let's accept there was no votes on the 28th of November 2024. That doesn't mean anything insofar as the V-Rays challenge is concerned. Because
No. It goes to your disaggregation point. It goes to your disaggregation point because you are making the point. Paragraph 41(2) of your client's affidavit. Can the votes be disaggregated? That's the principal question you ask.
And that's why we pleaded in the two alternatives. So if we can't get the disaggregated vote, then we say that the full relief, which is the setting aside of the entire election, must follow.
No, that's not what you are saying. You are saying the entire election must be set aside only if there is no proof, only if the court is unable to disaggregate. That's how I understand your case.
Yes, and I don't think we're speaking at cross purposes with all due respect. I'm agreeing with you.
Yeah, and you continue to say, if the court is able to disaggregate.
If the court is able to disaggregate. Yes.
Then we set aside only what happened after.
Yes.
Yes. So it means what happened before 28 stands. That's how I understand your case.
No, before 2100 on 27 November.
Yes.
Yeah, that's been our case from the outset.
Yes. Now they are saying, and your disaggregation point depends on there being no ability to disaggregate. They are saying, after the close of polls at 21 hours on the 27th, there was no voting that happened.
No, but they don't say that there was no voting at all. They say there was simply no voting on the 28th, but for, and it says, other than those who voted by virtue of being in line by 2100 on 27 November 2024. So they don't say there was no voting on the 28th. They say that there was some voting that happened on the 28th. And remember, what's relevant about the some voting that happened on the 28th by virtue of being in the line is that's an extension that rests in the hands of the presiding officers, not the president or the ECN. So even if the facts, as my lord puts it to me, is bad for the disaggregation relief that is sought, this demonstrates the unlawfulness that I was addressing at the beginning. And moreover, there's a further complication that arises from this, because what I was saying to the court before we started having the question and answers, if we go back to page 116 of Mr. Heathcote's bundle, is look at what the extension purportedly in the name of the president and coupled with the ECN says. He says he's extending the election from 2100 on Wednesday, 27 November 2024 until 30 November 2100. So now the further complication created by our learned friend's statement under oath in the answer is that where are those forms from the presiding officers that says we gave these people authority to vote? And that demonstrates why the extension is creating its own difficulties because, and I accept...
Mr. President, you are talking about forms. I want us to go to the facts. They are saying your clients asked for access of the National Assembly election material. You did not ask for the ones relating to the president. So how can you expect them to produce the forms if you could have asked for them and to get them? That's what they're saying on the papers.
But that takes us back to the issue about the founding affidavit where they were asked to produce that evidence, remember?
Counsel, we are bound by the facts before us.
Yes, I agree.
Specifically, your client said
yes,
they invite the Electoral Commission to do certain things.
yes,
And you reserve the right to reply.
yes.
What do you do in reply? You give a general denial.
No, it's a qualified denial with all due respect because it draws
You
this
can call it
exact...
whatever you want, you just say we deny.
No, with all due respect, my Lord Deputy Chief Justice, that's not what the client says in the affidavit. And from a plain reading of the paragraph that you pointed out to me, that is evident. Because what it says, we deny it to the extent that we rely on what we say above. And what we say above, having regard to remedy, is that if you can't disaggregate the votes in the way that we asked for it, then the full relief must flow.
That denial is what you intended to do in reply. That's the right you reserved.
No, because remember what happens is that the evidence doesn't come about. And so the legal conclusion drawn from that is to say that if that evidence is not there, then that demonstrates that the votes weren't counted correctly, and that has an impact on what relief the court can ultimately grant.
Well, I think I've given you sufficient opportunity to address my concern.
Yes, what I say is if I misunderstood it, I'll maybe come back and reply and try to understand it, respond to it a bit better.
Mr. On the forms you are bringing up now, the two paragraphs that I read out to you, LPM is saying we are not concerned with the irregularities. We're just after this one issue, the unlawfulness. We shouldn't even go there.
If the LPM's construction of its case of unlawfulness is correct, you don't have to, because you'd set aside...
You don't have to go there.
Yeah, you'd set aside...
irregularities,
that's
or
right.
these forms or
that's
whatever.
Right. You'd set aside with nothing more. That's right. May I take an instruction? I see I have 3 minutes left. Just two very brief points. The first one is that we know that our learned friends rely in paragraph 35 of their heads of argument. This is SWAPO, the 7th and 8th respondent, if I'm not mistaken, on the Amabungane judgment, and they rely on that to make a case for implied powers. We would say the following. The first one is no implied power can be claimed in circumstances where the application of that implied power contradicts the express provision. I started addressing this at the beginning. That's why an implied power to dismiss can live side by side with an implied power to hire. But an implied power to extend the election term after the polling period has closed can't be applied in circumstances where the statute tells you otherwise. The second point we'd make is that to the extent our learned friend's argument amounts to an argument in favor of something in public law called primary implied powers, we'd say this. We'd say that it's not up to the decision maker themselves to invent the powers as they go along. If there's a gap in the statute, that's a rule of law breach. Because what you know is a litigant in public law litigation can impugn a statute on the basis that it's vague. And it doesn't cover for particular circumstances where a decision maker, in terms of that statute, may need to make a decision. So we would say that in the balancing act between implied powers on one hand and the threat of vagueness on the other hand, this court has repeatedly come down on the side of the vagueness concern, because otherwise it would invite decision makers to make it up as they go along. The last point I wish to address is the one that emanates from our heads of argument as well, which is the one on joinder. I know there's a lot of, because I know the Chief Justice raised it. All we would say is we would refer the court to the two judgments that we rely upon in our heads of argument. Those are the ATM High Court matter, which endorses the principle that where the respondent wants to either join the applicant in supporting their relief or seek its own relief, that it must come in as a co-applicant and not as a respondent. Because then we'd be in this odd position where if we wanted some relief, we'd have to counter-apply against an application that we actually support, which seems a bit strange. And that was also endorsed by the Labour Court in South Africa in the matter of Kruger versus ACL. The last point I'd like to just make, as I'm 17 seconds over my time limit, is you know what we say on costs. We ask that BioWatch applies. Chief Justice, those are our submissions in opening.
Thank you, sir. Any other questions?
Yes, Council, I want us to go to
From the Deputy Chief Justice.
Yes, thank you.
page 605. Page 605 of the record.
Yes,
That's volume 2.
yes,
Two things.
yes.
In the first place, I forgot to test it with Mr. Katz. I'm sure in reply he can deal with it.
Okay.
There is this reference to the 36 constituencies being strongholds of the ruling party.
Yes.
What is the evidential basis for that? Do we take judicial notice? And on what basis do we do that? Your client also makes the case. What is the evidential basis for that?
It's the ECN records that's publicly available from the ECN's app, and we refer to that in the replying affidavit where we had accessed it. I'll get you the exact reference. I'll ask one of my colleagues to do so, if I may.
And that shows these are the strongholds
Yes,
of
that's
the
where
ruling
it
party.
was accessed, and if it's verified that will be demonstrated. Yes?
That's the first one. The second one relates to, and here I want you to help me.
Yes.
SWAPO or any other party with the ability to do so, which I suppose is to govern,
Yes.
would have needed to form a coalition government. Now, here you are before us,
Yeah, this is the presidential election.
how do you form a
No.
coalition government?
I take the point.
It's inadvertent.
I take the point.
Thank you very much. Thank you.
I don't know if my colleagues have the reference. Can we give you the reference in reply?
Yes, please.
Thank you. I'm
The
indebted.
Chief Justice allows, yes.
I'm indebted. Thank you, Chief Justice and Deputy Chief Justice.
Thank you, Mr. Premier.
Thank you.
Mr. Heathcote.
Thank you, my lords. May I, with your lordship's leave, we have prepared, and we've already handed to your lordships the statutory bundle, if I may refer to it that. And then we have also prepared a bundle of the authorities from the Namibian report, so that your lordships may have it in a convenient little bundle, because I will address the owners in due course with reference to those. May I hand this up? Those are all the Namibian cases, and then also the 1949 Taithi case from the appellate division then.
Are those additional to those that are already contained in your bundle of authorities?
They're not additional, my lord. They are all over the record. It will just be convenient. And then lastly, my lord, I also ask, because in the reply, Mr. Swartboy raised now, and he referred to the High Court judgment which was sort of stayed the proceedings pending the outcome of this. And I ask to hand up the results which can in any event be obtained in the Government Gazette to deal with in short in relation to that, how important it is, then if that is what the High Court thought, for your lordships to resolve GG 34, its legality, which is the Government Gazette of 28 November May I hand this also to you? Have you given them copies?
Yes, I have. Thank you.
Only 5. Thank you. My Lords, I will, in due course, refer to the statutory bundle and the authority bundle. That's the one I've just handed up. We will submit to your Lordships 3 categories of the argument, and it may sound mundane, but we respectfully submit as first to determine what this case is not about. And the second one is what this case is about. And once we've established that, we will thirdly apply the facts, which we haven't heard a lot about this morning, to the legal principles involved. It is of no use with respect to get an academic lecture on legality and read out aloud the principles of McFoy as if we must hear it for the first time, that a nullity is a nullity is a nullity. The question is whether it is applicable in this case. So, my Lords, what this case is not about is firstly that it is not about any calculation or adding up or so forth, or that there was a mistake about the elect 37. That seems to be the elect 37s. That is when the polling officer must place the result of a particular polling station on the wall. Now that is normally when people see the writing on the wall as well, because that is when the complaints start. And in this case, we've even had, and I will refer you to it, the extraordinary statement of Mr. Itula that even if he wins, he will set aside the election. But the fact that that has not been complained about, your Lordships will find how important a role it played in this court in the Rally for Democracy 2013 case, which your Lordships will find at page 127 of that bundle of authorities which I've just handed up, particularly at paragraph 128. And if you turn there at page 127, paragraph 128, this court says, what is more, notwithstanding the fact that the appellant had numerous party agents in the field, they could not refer to a single incident where the result announced by a presiding officer at a polling station differed from those which were used for the purpose of an announcement on constituency and national level. This, it seems, is also what the first respondent in effect alleges and what the court quo found to be the case. We are exactly in that same position where the results, the calculation, and the elect 11s, no one complains about that. One will remind yourselves, and perhaps Mr. Swartboy should, that in this entire election, he got, we point out in our heads of argument, a meager 30,000 votes or so, or 50. What this is also not about, and your Lordships will forgive me or pardon me for a moment if I say here that often what happens is that social media has one case and the court has got another case. before it. And the problem with that is that we live as lawyers in the discipline of the sub judice rule. But out there, regrettably, the people don't live in that world. Social media has become a place where rumors are spread, and eventually what happens is those people who are listening now today, because this is recorded, think this court is determining the issues which were on social media. And then once the judgment comes, they don't read it. They just see that their party lost. And the next thing you hear is the judiciary is captured. So it is very important, and the courts normally don't do this in the judgment itself because those matters are not before court. It is very important, if your lordships allow me to add, that this case is not about, with respect, and Mr. Swartboy and Dr. Itula does not say to this court or prove to this court that there was buses that came from Angola and offloaded many voters at some polling stations. That is not before. If you've read it in the social media, don't blame this court if it does not deal with that, because your leaders didn't bring such evidence to court. What we did read on social media, which is part of the papers before your lordships, is what we find in the documents, and I will refer you to it. First of all, what Mr. Itula said, that is now after, and the first one, his press statement, you will find at page 466, page 466 of the record. Now this is immediately after, on the 27th, and when the President decided to extend or publish GG 34. And now this is what is out there. On 466, I'll read some portions. He says, polling stations unlawfully designated as voting centers continue processing votes under the shroud of illegitimacy. Now, your lordships will recall that the IPC started off in the founding affidavit and said the President did mention or declare polling stations which were not previously declared. The answer is then from all the parties, no, it didn't happen. Look at the respective proclamations. They are exactly the same. Then it disappears, and this morning, Mr. Katz gets up and he says, well, I just want to point out, perhaps they will say I'm wrong, but here in Kunene it is not so. Now, my Lord, there is not a single polling station which appears as an annexer to GG 34 which was not part and parcel of the original polling station. We have pointed that out, and it is just frivolous to continue with it. But yet, in his press statement, Mr. Itula says, widespread disenfranchisement with voters turned away due to lack of ballot papers, brazen voter suppression, silencing the voices of Namibians, undermining the Electoral Act and its tenets. And so he continues, and he says, importantly, I call upon all citizens to document the irregularities, share videos, reports, and evidence with your parties. Let us expose the truth and reclaim the integrity. Where are all those? But part and parcel of that rumor mongering, your lordships will find in the record at page 470, when Ms. Agamus is now speaking. Well, I don't know whether it's a pun, but she refers to all the incredible evidence they have. I'm not sure what she meant with incredible, that no one can believe it, but it seems that she meant it's an incredible lot. And then...
Obviously, a misuse of the word.
Yes. But it continues, and on page 471, now again, there is this on social media. She says, we have got missing ballot boxes that are unaccounted for. We've got ballot boxes that are being transferred without the escort of the police. These are not part of these papers. It's not proven. So again, if there is somewhere out there that thinks this court is going to decide this issue, your leader didn't bring it to the court. But most importantly, at page 473, she says this, and that's also out there. That's what they think, their followers, says, this is what she says at 473. The provisions of the law say when you are challenging presidential elections, you should provide material evidence that there would be significant effect of the outcome of the election. If you got 100,000 Namibians who have been denied their right to vote, even though they were in queues on polling day, if we were to rely on the currency per seat and so forth, if 100,000 Namibians were denied their right to vote, which is what we are aiming for, and which is what we are gathering, very fast approaching that number. So out there in social media, the LPM says they're going to bring 100,000 affidavits to the court. The IPC, sorry. 100,000 affidavits. The LPM can't, my lord, they haven't got as many supporters.
I want to caution against us making unnecessary snide comments.
Thank you.
I want us to really focus on the real issue. And that's what I put to Mr. Kant at the beginning.
Apologize. Yeah. So out there is someone that thinking this court is going to decide that there were 100,000 people that were turned away, and then they get the result. If they lose, the court is captured. I want to emphasize again, not so much for this court, but out there, that those facts were not brought to this court, and don't blame the court if your leaders cannot come up with the promises they've made, the false promises that is. Now, it is also not before this court that certain parties who had less votes, and I'm not doing this for being funny, that's also out there, than members on their list. Now, if that is so, it is also not before this court. Then perhaps it's time for introspection, not complaints out there which the court is not going to decide. And I mean this with respect, and I say this seriously. So, if that is known to the public as it is to the court, we will then understand what this case is about. Now, may I then turn to that? And it is important, my lords, to go firstly to the notices of motion of both the IPC and the landless people. Now, the notice of motion of the IPC, your lordships will find in the, I'll give your lordship the reference in a moment. Now I've lost my file. No?
Yours. Page 3.
Yes, page 3. But I've now lost my file. Oh, there it is. So, I will, in due course, take your lordships with your lordship's leave, because it's so important that in the onus, when you speak about the onus, what is material? When is there a change or a rebuttal right or obligation that comes in? But all these things are driven ultimately by what is claimed by the parties. Now, when you read these founding affidavits, it seems that because somewhere in Kenya there was a court that once set aside an election, and then they use those exact same words, but they don't have the facts for it. As was pointed out by this court in the Itula matter of the previous election, it doesn't help to repeat the words of the Kenyan Supreme Court. You must have the facts to support that, and that's always absent here. But what is it that they're doing? And before I emphasize this notice of motion, I will refer to the authorities, but let me just make this clear. Firstly, the Act in Section 115 speaks about the provisions of the Act. In other words, the many, many subsections of about 50 or so sections in Part 5. Those are the provisions of the Act. Then there's a different and an additional word that is used, which is important. That same section 115 speaks about the principles of the Act. So you've got provisions of the Act and the principles of the Act. Now there is no section in the Act which says the principles of this Act are. It's not there. So the courts have identified the 7 principles which we have referred in our heads. And that is ultimately what you must go for and identify as an applicant and challenge one of those principles to get anywhere. So that is the provisions of the Act and the principles. And then you may, of course, have a principle, and this is very important in our respectful submission, which says limited by conduct or by something, or restricted, and which within the normal word of our law in under Article 21 gives a rebuttal obligation on the state. But there's a difference in speaking about a violation of a principle as envisaged in the Act, or a restriction or limitation, or something which happened which is neither a restriction or a limitation. It's just a provision of the Act which may not have been followed, or which some individual breached, like standing in the queue with a political party T-shirt. Now, if that happens, how on earth can it be said that a principle of the total people voting of the right to vote had been restricted, or for that matter, violated? So what does the applicant do in the IPC in Prayer 1? It builds in Prayer 1 and it says, the court must declare the proclamation, and it says in violation of the Constitution of the Republic of Namibia, and in breach of, now here they don't refer to the provisions of the Act, they refer to the principles of Part 5. But we know, my Lord, that they never identify the principles in their founding affidavit, other than possibly the right to vote. Now, this is building on Kenya law. So if you can set aside that, or get a declarator that the principles are violated, then of course Prayer 2 follows easier. So they say declaring the 2024 presidential election to have been conducted in breach of the Constitution of the, and as not in accordance with the principles, not provisions of the law. And then ultimately, if you have 1 and 2, then you probably say, okay, now it's easy, declare the outcome unlawful, and then also ordering the conduct of a fresh presidential election in accordance with the Constitution and the Electoral Act. Now, I wonder whether anyone, when he said that in a notice of motion, was contemplating what is he asking for. That's impossible. A new election cannot take place in terms of the Electoral Act. That is what they're complaining about all along, that you must have it 5 and 3 months and 40 days and 35 days, and it may not be extended because then it's so unlawful, and then we get a reading on law and legality, and then they come to paragraph 5 and they ask the court to breach the rule of law, because nothing can be said that you do these things in terms of the Electoral Act. As we speak, it's impossible, because the Electoral Act says, and I'll come to it when I deal with the law and the legislation itself. If I may then ask your lordships to turn to the notice of motion of the landless people, which is at page 276 of the record. Now, with due respect, it seems that people kick off with this kind of thing, and when they come to the court, everyone ignores what they ask for, also ignore the facts. We get a lecture on legality without referring to the act or anything what they're asking for. Now, with respect, my lords, this is at page 588 of the record. Yes, my lord. Now, this, with respect, seems somehow I would respectfully submit. We know Mr. Swartboy is a lawyer, but it seems that at some stages he drafted the affidavit himself, because it still refers to instructions and so forth, and the draft. But I will refer your lordships to that. 588, Chief Justice. Now, this is a potpourri of wishes with respect. Let's ignore paragraphs 1 and 2 for the moment. Again, setting aside in paragraph 3 and declaring proclamation 34 and the annex scheduled thereto as violating. So they're not infringing or restricting or anything. They're violating the Constitution of the Republic of Namibia, including but not limited to articles. Now your lordships must take a deep breath with respect. 5. Now 5 is simply, in our context, telling what the executive must do. How that proclamation can be in contravention of 5, then 10. Now we know we've got 10.1 and 10.2. Those are not properly identified. 17 is in fact the right to vote. Now, what they ignore with respect, and may I, is your lordship, Mr. Justice Damasek, not 5. Thank you, my lord. So, what is it that the president did? No one has ever answered this question or stated to your lordship. What did he restrict? Or the president in GG 34. What did he restrict? He didn't restrict a thing. He didn't limit any right. He gave effect, opportunity for those who wanted to vote to vote. So there is no restriction in GG 34 as far as the right to vote is concerned. The president did the perfect right thing. The question is, could he do so in terms of the law of the land? And I will demonstrate to your lordship, there is absolutely nothing indicating the contrary, that he could not use section 9, that's 9.1 and 9.2, of the interpretation proclamation. You will find that the Nigerian constitution, the Kenyan constitution, so many other constitutions in Africa have in their constitutions that section 9, that you may do when it is required and necessary as occasion requires. That is not only in African constitutions, but also in American constitutions, the state constitutions. So, but that anyone that looked on as occasion requires an election law will see that it's been applied. But of course, you must now study the electorate act of that country, so it's not helpful to hand it. We must determine the answer in our own context, and there is nothing to the contrary. They use the word, they've only got one complaint, and that is before. Now, I will demonstrate to your lordship that the word before is not in section 63, it's in 93, where you must change the polling hours. That is by the commission, not the president. 93, my lord. 93-2. So, but if I can then continue for the time being, then you've got 18 in paragraph 3 on, but I thought that they said they're not doing an administrative law review. That's what I'd read in the reply and in the heads. Then there's 21. I'm not sure what 21 does. Is it religion or what is it? 22. How does that feature here? 22 is, no one explains in the founding affidavit. 25 is actually the constitutional provision which you must rely on to come to court. Now you want to say the GG 34 is contrary. No one kept them out of court. 27 is just the head of state. 28 is the election of the president. 29 is the term of office of the president. How does GG 34? 30, this is possibly the most hilarious. 30 says how the president takes the oath when the president-elect is appointed. Now, in throws someone in this notice of motion that GG 34 also is against the oath. Then you've got 46 is representation in the National Assembly, my lords. 49 is the composition of the National Assembly. Now, this is what happens. And then we say it's frivolous. This is frivolous, as is the others. So what must you do with this? And then you get to paragraph 4. Now they're getting worked up. Setting aside and declaring the impugned proclamation contravenes the Electoral Act as amended, including but not limited to 63, 64, 72 is nominations. Long time ago. Nominations, 73 concerns nominations, 75 concerns nominations, 77 concerns the submission of party lists, 78 concerns publication of the party list, and 93, that's the one on the polling hours. Paragraph 5.1 to 5.3 is false with respect. May I point out, the resolution, your lordships must declare to the extent necessary, well, if it's false, it's not necessary, but so it says 5.1, the resolution of the third respondent, the Electoral Commission, to draft the impugned proclamation for signature for the first respondent. There is absolutely no evidence that the ECN drafted a proclamation for the president. And the more we answer it, the more they get up and just continue with their facts. And then they say, well, we are bound by Plascon Evans, but they certainly do not apply it. That's why we have these lectures and not principles applied to the facts. So 5.2 the decision of the ECN, pursuant to the recommendation of the Attorney General, requesting the 6th respondent, the Minister of Presidential Affairs to gazette. But no one, my lords, asked the Presidential Affairs Minister to do a gazette. It is explained in the answering affidavit. That is the process. You don't just write to the President. But no one asked for this to be withdrawn or we must come and defend it. 5.3. The President's decision to sign and otherwise enacted the impugnment which thereafter was gazetted by the Minister. By the Minister. Must I continue?
Proceed. It's a few minutes left before.
Can I just finish this,
Yes,
my
yes.
lord, with your lordship's leave? So I've pointed out in paragraph 5.3, they wanted a declarator to set aside or say it's unlawful the President's decision to sign and to otherwise enacted the proclamation, which was thereafter gazetted by the Minister. Where's that? Who lives in La La Land here, with respect? Paragraph 6 is also false. Further and alternatively declaring that the President's decision and of conduct in respect of the impugned as on the basis that such decision and of conduct was mala fides and taken in bad faith. Where's the evidence for that? Who even considers putting that in a notice of motion? But paragraph 7 is sort of, let's just assume your lordships grant this and it'll bring us back to the frivolousness. It says pursuant to any of the declaration. So if you can get any of these here above, then declaring the conduct of the 24 held separately, including all ballots cast on these days as unlawful. So that is assuming they can get any one of the above. Then, if your lordships go to paragraph 8.1, they now running some sort of election, and then in 9.4 is the epitome. It says that any of the parties, 9.4, that's at the foot of 5.9. That any of the parties in the LPM, this is their landless people application, have the right to vary this part of the order. I.e. prayer 9.1, if a variation is needed. So they ask your lordships to grant the order and then your lordships should say to the parties, well, if you guys want to vary it, just feel free. Now, with respect, it will bring us back to the frivolousness of the Swart Boy application at the end. To stop at this portion, the notice of motions both wants an order that some principle was violated, and that principle is not identified or it's not explained how it is violated. And that should be the end of the story. And then the last guy that said finish and clar ended up in jail, so I didn't want to use that. My lords, may I start at 2:15 then, or whenever?
Very well. Now, this will be a convenient time for the court to adjourn. We'll resume at 2:15. 2:15.